Hey everyone. First and foremost, thank you for being here. And please indulge me just a little bit on this intro. It'll be just a little bit longer than normal. Some of you were asking in the comment section who Jay was, and Jay was my main moderator. So if you weren't hanging out in the chat during the live streams, you probably did not get the chance to interact with her, but she was an amazing lady, and her loss will be felt for a long time. But thank you everyone for your kind words, and like she would say, let's go. By the way, did you know they still sell Aquanet? Like same stuff from the 80s. I needed some for my craft stuff. And so I was going to get hairspray and I figured I had to get some foo-foo hairspray. Nope, still have that 99-cent Aquanet from the 80s. I tried to do my 80s hair. I got my 80s earrings on. I got my 80s tie-dyes on. Maybe it's 90s. Is it 90s? Kind of a crossover. Didn't work. Wanted to go old school, but I'm too old to go old school. Which kind of leads me into this video. What happens when the person sitting on the bench is old school? They believe that things have always been this way. That's how they should be. Is that how they should always be? And are they wrong for thinking that? So this is a case that was appealed from the district court related to the naming of a child and the custody agreement. Of course, we are not able to get all of the details because the nature of the case that is sealed. However, they do a pretty good job of explaining what happened in the district court during this appeal itself. We don't have the resolution. Be forewarned, that usually takes 4 or 5 months before that comes out. And this isn't really about the resolution. It's kind of about what do you think in this situation? How should it be handled? All right, let's go to court.
And Your Honor, if it pleases the court, I'd like to reserve 2 minutes for rebuttal, please.
2 minutes, yes, sir.
Thank you, Your Honor. May I begin?
Yes, please.
Your Honor, this is a paternity case, custody case, that was tried all the way back in March of 2021. Neither counsel present before you today were on that case at trial. We both took this case on appeal only. The essential facts of the case, I represent the mother in this case, Brittany Michelle Gray. There's one child at issue here who at the time of the trial had just turned 3 years of age, a young boy. Obviously, opposing counsel represents the father. Your Honors, I've raised 7 issues, and I'll try to go as quickly as I can. I know time is of the essence. The first issue, Your Honor, has to do with the surname of the child. I will tell you as a preface that this was a very unorthodox trial, as evidenced by the record. 2 cases had been consolidated, the termination of parental rights case and a paternity case. The termination of parental rights case, 3 days before the trial, it was announced by then counsel that it would be non-suited. On the day of the trial, an order was entered to that effect. A continuance motion made, it was denied, and they tried the case on custody issues. The record reflects that the trial itself was very streamlined and unorthodox. I'll just say that. With respect to the surname, the trial court ordered that the surname of the child be changed to that of the father. I want to point out to the court that Barabbas v. Rogers controls all of that issue. I've cited it in my brief. True to form with respect to the way this case went, factors 1, 2, 1 and 2, there was no evidence whatsoever as to those factors. Factor 3, which is the length of time the child had its present surname. At the time the child was 3 years old, that was not obviously not disputed. The child had lived in Tennessee his entire life. That was not disputed. And the child had lived with the mother and her family, whose surname was Gray. That was not disputed. And so, if anything, that factor favored the mother. The only arguable factor, as cited in their brief, that father even could argue, is factor 4, the degree of community respect associated with the present and proposed surname. The surname in question is Rafi, and with respect to that issue, it was cited in the appellee's brief that there was a couple of statements made in the trial about the fact that that family is well known in the community. That's the limit of it. So not even any reference to respect, which is different from simply being well known. Obviously, it could be, if we had to speculate, they could be very popular in a good way. They could be very popular in an infamous way. We simply don't know. This case is so much, or this appeal is so much about what is not in the record. And so there's nothing in the record that, in my opinion, would fit under the factors of Barabbas.
The judge said traditionally our children take the father's name, and that will be the case here. That's not a factor, is it?
No, Your Honor, and in fact, I cited that, and thank you for pointing that out. Judge Hargrove that was her statement, that traditionally the children take the father's name. In fact, she said our children take the father's name. And respectfully, and I've tried scores before she retired of cases before Judge Hargrove, both good and bad, and that's classic Judge Hargrove, and I have great respect for her, but respectfully, she should not have relied on that factor. So she picked one factor that wasn't even one that she could rely on. So respectfully, our position is there wasn't sufficient proof in the record for her to change the surname of the child, and that the court should reverse with respect to that issue. I'll move on, Your Honors, to the second issue. The second issue was whether the trial court erred in ordering a permanent parenting plan schedule without findings of fact. Respectfully, given my time, I'll just rely on my briefs there, and I'll just simply say there were absolutely no findings of fact made in accordance with 36-6106 with respect to the factors. Obviously, that puts us in a situation of having to guess what the court was relying upon. There was a reference in the appellee's brief to Judge Hargrove's finding that my client was vindictive. Respectfully, I don't believe the record bears that out at all. I think.
Well, didn't she tell the father that she aborted the child?
Well, the father alleged that, Your Honor. That I believe that the court said that had been alleged at a hearing. In fact, and I don't want to misstate, but I believe that might have even been a previous hearing that had been a pendenti lite hearing in the case. I don't believe that was said at trial in either direction. In any event, father had made that allegation, and it made its way into the findings of fact. Your Honor, the third issue is a unique issue regarding the structure of the parenting plan. One particular provision allowed for the father with 10 days notice to have unlimited time in the state of Tennessee with the child. Our position is that that violates the court's discretion in this case. In looking at looking at what the court should be able to do, respectfully, and I quoted this on page 14 of my brief, only when a trial court's ruling falls outside the spectrum of rulings that might reasonably result from an application of the correct legal standard to the evidence found in the record, and that's describing abuses of discretion. In this case, I've, again, as someone who's tried at this point hundreds and hundreds of custody hearings and then also trials, it is not acceptable to go with the remedy from the other side, which is to simply say, well, she can always file to modify if it becomes an issue, or he's probably not going to exercise that provision. Respectfully, that's not appropriate. She should not have to worry that he's going to exercise that, and so we believe that abused the court's discretion. With respect to the fourth issue, Your Honor, and I'm sorry I'm going so fast, but I'm limited with time, whether the trial court erred in refusing to present evidence at trial that predated its January 27th, 2021 pendenti lite motion hearing. Respectfully, at the beginning of the trial, and I put this in my brief, and Your Honors can read it, there were multiple times when my predecessor counsel attempted to go into information that predated that. It was pointed out in the opposition brief that there was some evidence, in fact, that the judge considered, such as an IEP that, for this child, that was considered with respect to, that was before that date. However, what's interesting about the record, she seemed to only allow that if it was favorable to father. Respectfully to Judge Hargrove, what she did is essentially is from the start did not permit my client's predecessor counsel to try that case.
Why did she choose to do this, did she say?
Judge Hargrove, Your Honor?
Did Judge Hargrove choose to limit it to the 47 days?
Your Honor, I think it's a Camacho issue. I think that Judge Hargrove, my experience with her was that she was used to, once she heard it, Pendenny Lottie, she didn't want to hear it again. And so I think, again, in opposition to Camacho, which the court's well aware of that decision, what that simply meant was we really couldn't try our case. Now, I do want to say this, if it's suggested that there should have been an offer of proof, the problem with that is that if there's an offer of, at that point in the beginning, multiple times, suppose our predecessor counsel was trying to get information in from prior to that date, and she was stopped by Judge Hargrove, she would literally have to try the entire case as an offer of proof. And I think at that point, it's just a little bit absurd, quite frankly. I've had plenty of offers of proof, but I haven't had to try a whole case under the guise of an offer of proof. And so respectfully, I think the record is clear of the issues she was trying to go into. They were fair issues, and Judge Hargrove just had a blanket rule that, at least with respect to mother's counsel, was not going to let her go into that. That's unfair, and it frankly allowed for a situation where my client couldn't try her case. It's that simple. With respect to issue number 5, we had an issue of retroactive application of child support. I'm just going to say right now, Your Honors, that's our weakest issue. Out of the 7, that's our weakest issue. I believe in it. I think it is right that it should be considered. In fact, Your Honor, there was a quote from the court, and I do want to point this out on page 24 of my brief, that I thought was telling, because respectfully, Judge Hargrove was, in my opinion, not fair in this case. She said, due to the facts and circumstances of this case, as well as the late voluntary dismissal of the petition to terminate and for adoption, an award of retroactive child support is not appropriate. Judge Hargrove respectfully should not have said, just because my client non-suited a termination of parental rights petition prior to this trial, that somehow that plays a role in whether or not retroactive child support, which the statute says must be applied unless certain facts exist, but certainly it can't be one of the factors that gives the court an out from doing this, that my client non-suited a termination case. And so respectfully, she was abusing her discretion there as well. With respect to the 6th issue, there was a huge award of attorney's fees. I'll just tell you, in Murray County, and this is beyond the record, but I'm just saying this by way of argument, that a $50,000 award of attorney's fees is exceptionally rare in a domestic case of that nature. It is very clear from the record, and I'll rest on the brief on this, that Judge Hargrove was upset about the termination case. The 2 cases were filed simultaneously within 48 hours of each other. They rode alongside each other. There was no finding by the court with respect to the factors related to the Connors, excuse me, I'm getting my situation here mixed up. No, Judge? Yes. I apologize. Yes, I'm sorry. The fees regarding these under Connors versus Connors Supreme Court decision, there are 6 factors. I won't go through all of them, but it speaks to what you would think logically should be spoken to when a judge is weighing whether or not to award any attorney's fees, much less a large amount. And I want to point out some things that I pointed out in my brief. Paternity was not contested in this case. Custody to my client was not contested in this case. Current child support was not even contested in this case. And then the court, of course, only limited proof to a window of 47 days. So it is frankly shocking that you would get $50,000 worth of attorney's fees out of that. Now we'll add in the brief, in opposition, it was pointed out that, well, mother hasn't actually paid that yet. She bankrupted out of it. In my opinion, well, she's still paying, but the fact of it is that's an underscore to the problem here. She had to file bankruptcy because of this massive fee order. We asked for a bond to not have to pay this at that time, the judge ordered a $60,000 bond, which my client could not make, and therefore her only other option was bankruptcy. The last issue, I'll be quick, is that technically the judgment is against Stephanie Gray. Stephanie Gray is not a party to this paternity action. She was a party to the termination action, which was dismissed. It's inappropriate and violates all manner of notions of due process that Stephanie Gray would be included in this. I believe she could collaterally attack it if there was some sort of attempt to collect, but I don't want it to go that far. I would appreciate this court simply saying that Stephanie Gray is not an issue here, and any judgment, if it still exists after this appeal, should not be against Stephanie Gray, but only Brittany Gray, her former spouse.
All right, thank you, Mr.
Thank you,
Watley.
Judge.
The judge that they keep referring to is Judge Stella Hargrove. She retired from the 22nd Judicial Circuit, which is Maury County, Tennessee, in August of 2022. She actually became a lawyer in 1977 and started her judgeship in 1998 in the 22nd Judicial Circuit, which includes Giles, Lawrence, Maury, and Wayne counties. Those are small little counties right in the center of Tennessee along the Alabama border for the most part. Interestingly, in the article related to her retirement, she says that prosecuting domestic cases were difficult, termination of parental rights. They are very emotional and difficult. All of them are appealed, of course. They still have a lot of them pending that I will see through. 2 years later, they're still going.
Good morning.
Good morning, Your Honors. Attorney Adam Zanitas for Rami Rafi, the father in this case. And may I proceed?
Please.
I think the first issue that Mr. Watley got into here was changing the child's surname. I think this court's already pointed out that tradition isn't one of those factors from the case law. The first factor is the child's preference. The child was 3 years old, had autism and delays, so I don't think his preference could have been known at the time of trial. The second factor is the change's potential effect on the child's relationship with each parent. Again, the child was 3, had just turned 3 at the time of trial, so I don't think that factor would have applied. And then the length of time that the child has had its present surname. So at the time, it had been about 3 years the child had been with the last name Gray. Now, since that trial, when the last name was changed, the minor child's last name has been Rafi since that time. So technically, as we stand here today, the child's last name has been Rafi legally for longer than it was the day of trial. This is a little bit unique in this case in that the appeal was filed in 2021, and here we are in 2024. So a lot of the facts that were introduced at trial in this case are completely stale now. I mean, you're dealing with a 3-year-old versus a child that's about to turn 7. So I don't know how it took so long to get to this point, but that's where we are. The fourth factor is the degree of community respect associated with the present and proposed surname. There was some testimony, not just by my client, but by his mother about everything they do in the community, about how his parents owned an athletic complex where all the families come in and they know everybody around. So there actually was some proof presented. I don't think the intent of that proof was about the surname, but it could certainly be used to address factor 4. And I don't think this last factor applies either, whether or not the child would be harassed essentially or embarrassed because of the name change. I don't think that would be a factor either. So while I agree with the court that I don't think Judge Hargrove should have relied on tradition, I do think that it was within her scope to go ahead and order that the child's last name be Rafi. The next issue raised by Mr. Watley, it was actually raised by the court. The court asked the question, did she not lie to the father about having an abortion? So the first pendant light hearing in this matter, there was a court reporter, and that transcript was filed with the court. Judge Hargrove mentioned during the course of the trial that she had reviewed the file and that she had read everything, and part of the record was in fact that transcript, and she said she had just read that transcript. So within the transcript, the father goes through in great detail about how she said she was going to have an abortion, and then the first time he found out about the child was seeing posts of the child online. And then I guess he also testified that mother's mother, so the maternal grandmother, reached out to him and confirmed this child does in fact exist. Immediately, he got a DNA test done, and immediately after that, he started paying child support and visiting with the child. So I think those facts are very important. I think Judge Hargrove was probably very upset with mother after considering those facts. The other side of just the facts leading up to the time of filing, Gray is not Mother's original first legal name. I mean, she changed her last name to Gray after she got married to her now wife. And then when the child was born, the name Gray was on the birth certificate with the stepmother technically signing her name under father. So knowing she wasn't the father, she still decided to do that. Within the petition that was filed to terminate parental rights, both Stephanie Gray and Brittany Gray signed this under oath. And they said that my client abandoned this child. They said that he did not pay any support. They said that he did not make any efforts to visit this child at all. And at the first pendant light hearing, if you read the transcript, it's very important. He started paying immediately. And there was proof presented and entered into evidence at the pendant light hearing. And then when we come all the way back to 2021, 3 years later, when they come to trial, the attorney representing Mother stood up and said, well, it just came to light that there may have been some payments that we weren't aware of. They had already gotten that proof at the first pendant light hearing. So that was a complete misrepresentation to Judge Hargrove, who, by the way, had just read that record. So from a public policy standpoint, we can't have a parent, a step-parent in this case, being Stephanie Gray, come in, sign a petition under oath. She signed it too, alleging that this guy abandoned his kid, carry on litigation for 2.5 years, and then wait till the day of the trial to make it an oral announcement that they're non-suiting the case. She can't possibly get away with that. Judge Hargrove also made a note that a person going through a termination of parental rights, it's almost like you're going through a sentencing for an execution. I mean, that is what it is, and I know they dismissed it, and I know we didn't have to try that case, and I wasn't part of the trial case anyways, but he had to go through 2.5 years with this hanging over his head, and they just decided to dismiss it at the last minute. So we cannot allow people in this state to actually sign off on these TPR petitions just because they're trying to essentially steal away this kid and to get away with it and never have to pay attorney fees. And that's the argument as far as Stephanie Gray goes, owing attorney fees. And her name is on the caption for every pleading. I mean, the case was consolidated for much longer than it wasn't consolidated. For 2/3 of the time, those two cases were consolidated. And coming back to the attorney fees, I cited to In re Nathaniel C.T., and it's really the only case I could find that was kind of very close to this case where there were some custody aspects and it was a termination of parental right case. And the standard they set forth for determining whether or not attorney fees could apply is you've got to figure out, is it more of a custody case or is it more of a termination of parental rights case? And in this case, I think it is absolutely clear that at the end of the day, it ended up being much more of a custody case. There were 4 to 5 pendant light hearings where they dealt with temporary custody of the minor child throughout the 2.5 years of litigation. They dismissed their TPR case on the very last day, being the trial date. And my client exercised parenting time and paid child support throughout the course of litigation. So everything that was technically litigated was more so a custody case. I think we know that when you're going through a TPR adoption case, typically there is a home study that's done. Typically if the court's going slowly, someone will file a motion to expedite because it's supposed to be expedited according to statute. But mother and stepmother, they never did a home study. They never filed a motion to expedite the case and get it set for trial. So they didn't really treat it like a custody case once my client actually or they didn't treat it like a TPR case once my client actually got involved. And I think what really happened in this case is that their initial pleading, this petition that had all these, frankly, lies, backfired majorly. And Judge Hargrove wasn't happy about it, and I don't blame her for not being happy about it.
Under the custody attorney fee provision, who may the court assess attorney fees against?
To the prevailing party. So
Against whom?
I have the statute here. Let me see exactly what it says. Well, obviously, I mean, I think the quick answer is the non-prevailing party. And in this specific instance, there were 2 parties that were not prevailing. I think their argument is...
Well, now, how is the stepmother a party to the custody action?
I think by statute, and I go through this in great detail in my brief, but by statute she was until the very moment that she decided to non-suit. But the custody case certainly did combine statutorily with the parentage case. It just does. And so once you do that, there's been an adoption filed too here. We can't forget about that. So once the adoption is filed, if you look through the statutes, the adoption court, being the Chancery Court where everything was consolidated, they have sole jurisdiction over custody of the child at that point. And that's in the statute. And as far as that goes as well, they are required to make a determination as to attorney fees when they're adjudicating issues of paternity. So I'm sorry for Miss Stephanie Gray that all this got combined into one case, but it did. And until the very last day of the whole case, she was a party to this case. So I guess the point I'm trying to really hit home here on is by non-suiting her case on the last day, she simply cannot escape liability. It would be tremendously bad public policy to make that a rule, where you can go through litigation for 2.5 years, making someone think they may lose their child, and then just non-suit it and completely get away with it. It just doesn't make any sense. I want to backtrack just a little bit. I know that obviously Mr. Watley raised the issue that Judge Hargrove didn't necessarily go through every single best interest factor. I think this court has a lot of cases that come up on appeal where that's a big issue, and trial court judges aren't really going through it as thoroughly as they probably should. I think we'd have to concede here that, yes, Judge Hargrove probably could have done a better job of going through all of her reasoning and making additional findings of fact. But at the end of the day, we have two parents who entered proposed parenting plans where they suggest that dad should have 93 days of parenting time and mom should have 272. That is the number of days that each party received when this case was finally done after Judge Hargrove entered the final order. The big changes that were made, essentially, mom was suggesting these very restrictive provisions in her parenting plan where my client shouldn't have overnight time until the child became verbal. My client should always have someone speaking English around the minor child because she alleged that my client's family couldn't speak English. He testified at trial that was a complete lie, and everyone did actually speak English. So a lot of these restrictive provisions Judge Hargrove just struck through and did not include in the overall parenting plan. So if you read through the transcript, she did adopt my client's parenting plan, just making small changes. So I think my client's the prevailing party in that regard, but at the same time, they've not suggested anything in their brief as to what parenting schedule would be better for this child. So I don't really even understand making the argument about the best interest factors if you're not going to tell the court, hey, this is what she should have done based on the evidence presented, because they didn't do it. And unfortunately, I had a case in this court where the court found that, and this is the Channel-Richardson case, and the court did find that the trial court got some of the best interest factors wrong, but at the end of the day, the court told me, hey, you've not really suggested what plan would actually be better for this child, so I didn't have any changes on appeal. I think that's very similar to this case, because they're just complaining that she didn't go through the best interest factors, but they don't tell us what plan would have been better. And I understand that there's an issue with this unlimited parenting time in Tennessee, but the facts that Judge Hargrove heard, and mom elected not to testify, by the way, so the facts that she heard from my client were, I'm a very busy real estate agent, so I can't come to Tennessee all the time, and the duration of time I can come will be limited. So I think it had to have been that Judge Hargrove just knew this guy wasn't going to come for 2 months on into Tennessee. You can't do that if you've got active listings in Texas. You just can't do it. So I understand that she didn't place a limit on the time you could exercise in Tennessee, but this does not demand a new trial, Your Honors. The last thing either of these parties really need is a brand new trial. My client spent $89,000 in this case at the trial court level. I'm assuming that mom spent a comparable amount. They don't need a new trial. If that's the big issue in this case, and we don't like this provision about unlimited time in Tennessee, place a cap on it. This court is capable of doing that. Say the maximum amount of duration of time you can spend in Tennessee with a child is 5 to 10 days, something along those lines. It doesn't take a brand new trial. It doesn't take a full remand to determine that. The issue
We can't even remand for findings of fact because Judge Hargrove has retired, right?
Unfortunately, Judge Hargrove has retired, so that's why I'm really hammering home that this court can certainly place that cap on there for us if this court finds that provision to be troublesome. And, frankly, I don't know if the court had the opportunity to examine the parties' incomes. There was some income information put into evidence. I believe at the time of trial, my client was around $4,000. She was around $1,800. These parties cannot afford to have a new trial. They have a small child they need to take care of. Every time a new trial comes about, this child's just going to receive less. Limiting proof to 47 days. I went through this in great detail in the brief. It wasn't technically limited to 47 days for all issues. There was an IEP entered that predated the 47 days. Additionally, witnesses testified about things that occurred prior to that, and just generalities, too, about the child and what the child's been like growing up and things like that. So there was some evidence presented prior to the 47 days. And I also want to stress that the Camacho case that's been quoted in that case. I actually did the trial in that case, just coincidentally. But Judge Parks down in also Murray County, he was relying on memory of testimony from a year prior, okay? And this court found you probably shouldn't do that. But this case is different because Judge Hargrove was relying on transcripts that were in evidence. And as far as the 47 days go, 47 days is not a long time ago for a judge to recall what happened. Okay, 47 days is a lot different than the year of time difference in Camacho. So I don't really think that case is necessarily on point. And I think that the Crow case that's also cited, that was a criminal case where essentially a judge ruled on a probation hearing based on facts he heard during a trial of a different matter for the same defendant. So I think that's a lot different than this case too as far as the facts go. Circling all the way back around to attorney fees just very quickly, my client ended up being awarded $48,627. His attorney fee affidavit that his attorney submitted was, I believe, for $89,000. So I understand, according to Mr. Watley, this is a large judgment for Murray County, but it's almost half what my client was actually billed in this case. So I do think that the court took under consideration that, okay, these parties, neither of them have a lot of money, but Mr. Rafi is the prevailing party and he's entitled to fees. I know it might look bad for her just saying, in large part, due to the mother's vindictive nature, I'm doing this. But if you look through the actual transcripts and if you look through all the pleadings, she opposed any increase in parenting time throughout the entire 2.5 years of litigation. I mean, my client had to incur fees just to see his child, and there were never really any facts presented by mother indicating my client wasn't a good parent. At the final trial, she didn't elect to testify. I think that's very important. I think that if she wanted to raise all these issues on appeal, maybe she should have tried to testify and get some facts into evidence, because she didn't even try to do it. So to me, that's very important too. So I think she actually waives a lot of these arguments by not making an offer of proof and actually trying to get some of the stuff into evidence. That's all I have unless there are further questions.
All right. Thank you, Mr.
Thank you.
Zanitas.
Thank you.
Mr. Watley, your rebuttal.
Thank you, Your Honor. My client can ill afford this as compared to the other party because she is $50,000 behind the start because of this judgment against her. I will also add that the case law that I cited is very clear that one cannot receive attorney's fees in a termination case, and there is no way under due process or any notion of law that Stephanie Gray was part of a custody case, even though they were consolidated for purposes of the clerk's working and inner workings of the court. In fact, I would even argue that the idea that they would be tried at the same time is inappropriate because of the different standards of proof that would apply. Clear and convincing evidence for a termination of parental rights and preponderance of the evidence with respect to a custody case. And so that's inappropriate. So actually my client's ex-wife did a favor to the court and did a favor to Mr. Rafi. I will also say that with respect to Judge Hargrove reviewing transcripts, which are from Judge Allen, by the way, this issue of the abortion, and there might have also been an issue about my client's sexuality in there, I'm not sure, but be that as it may, I'm not aware of any findings of fact that actually took place. So Judge Hargrove can't read a black and white transcript, make a finding of fact in the trial on the merits that it was true, which is exactly what she did. That's inappropriate. In other words, for some reason she read it in the black and white transcript that he said it, she accepted it as true. And that's the problem here. Just a couple of other issues, Your Honor. Jones v. Jones, I don't have the site. That was my case 10 or 15 years ago in front of this court. Out of Dixon County, Tim Potter was on the other side. Judge Sexton failed to make findings of fact in that case. We fought and fought and fought. And ultimately this court said, yes, you're correct. But he retired, I believe it was Judge Sexton, he retired during the appeal. So it was ordered for a new trial. So I'm sorry I don't have that site, but I could get it.
So do you want a new trial?
We do.
Okay.
All right. Thank you both for your arguments.
Thank you, Judge.
Call the next case, please.
Vanessa Vadul versus Edward James Bayer.